ಅಯ್ಯೋ ಬಂದ ತಕ್ಷಣ ಬಂದ್ಬಿಟ್ಟಿದೆ.
ಇದೆಯಾ ಮೌಸ್ ಇದೆಯಾ ಮೌಸ್ What was the order though?
Wait, you tell him. You tell the court of. You tell him whatever this.
MFS 7124 of 2016 is allowed. The impugned judgment and decree dated 6/9/2016 MC5 of 2014 on the file of family court at Tumkur are set aside. Consequently, MC5 of 2014 on the file of family court Tumkur is dismissed. MFS 7637 of 2007 is dismissed. The impugned judgment and decree dated 31/8/2016 passed in MC number 36 of 2013 by the principal judge family court at Tumkur is confirmed. No address to this.
Great, Your Honor.
I am for petitioner, my lord.
What office objection?
Not full cost title has not been filed in the IM, my lord.
Allow that. Happy presence heard on IA 1 of 2022. After hearing learned counsel for the appellant, office objections ignored and below reasons assigned in the application form are duly supported by an affidavit order dated 25/3/2022. FA 1965 part 2012 file and below I is allowed. Let the appeal be listed for final hearing immediately.
Much obliged, my lord.
So you will have to argue, Mr. Whenever it comes up 2012 matter.
Yes, my lord. I will be ready, my lord.
So this notice has been issued on the IAS. Presence made by learned counsel for the regard to clarification of initials of respondent number 5 is accepted. And below issue notice of IA 1 of 22, 2 of 22, and 3 of 2022 to proposed LRs of disease respondent number 5. Shall we take your statement? They do not survive. All right. Current counsel for the appellant submits that the memos as well as interlocutory application do not survive for consideration. Let the appeal itself be listed for final hearing in next week. View of law 9 below in view of law laid down for next week, right? In view of law laid down by Supreme Court in Nish versus Neha, citation 2020. Parties are directed to file affidavit pertaining to assets and liabilities. Like we used to find difficulty, Mr. Just sharing of the case. I was just reminded. So we used to find difficulties in remembering the equations of organic chemistry. So, like the teacher who used to teach us, he used to say that he had a pet. So he used to say that even if I ask him, he will utter the equations of organic chemistry, formulas of organic chemistry. You are a human being. So like this, the effect of we dealing constantly, everybody knows. He also knows.
My lord, I am appearing for the respondent in this matter. The appellant counsel was retired, my lord, is in 2021 and memo was filed. And the person was the party in person was appearing, and he is
You are not appearing, right? You are not appearing.
No, I am for the respondent, my lord.
Time to filed on behalf of Mr. Rajesh S. Learned counsel for the appellant seeking permission of this court to retire from the case is accepted. Accepted, Mr. What's your name? Mr. So and so Learned counsel. Place what? Accepted how much time? This is 2017. Base fund is granted 10 days time to enable him to file wakalat and to argue the appeal on the question of maintainability.
Please, my lord.
Number 6, E.V. Ramesh Babu. Time notice he should take steps. How much time? 2 weeks. Council for the absence pays for the job. Take 2 weeks time. Enable him to take steps. A substituted service on respondent number 682. You are appearing for R5D. When? At the date. For appearing for which response? Respondent R5A to C and E and H submits that respondent number D has died issueless on 7/5/2021. In view of aforesaid statement is placed on record. Office objection is ignored. Yeah. For the apple. Itself is right. So for respondent, he states that.
I appeal for the length. I request for a week's time allowed in this matter. Such steps in
The appellant based on 10 days time to enable him to take steps to comply with office.
Right.
Rectification of retirement. This one.
Of retirement miller, MR Sinchan, not chairman. Yes, ma'am. Sri name of Sri Ramesh Chandra. Ramesh Chandra for a second respondent. He's a
Filed on behalf of what? Who?
MR Sinchan.
Retirement, seeking leave of this court to retire from office is directed to delete her name. Office, let the name of Ramesh Chandra
Ramesh Chandra.
be elected as counsel for respondent number 2. On taking of steps. Learned counsel for the appellant submits that respondent number 3, 4, and 5 have and 7 have already been served in view of a proposed submission. Office objection with regard to non-service of the respondent is no. He has been admitted no. Let the appeal be listed for final hearing. Is Mr. Ramesh Chandra. Acha. He is appearing for respondent number 2. Then yes. This is to be heard finally, right? You are not interested. No. I'm not interested to argue. Busy in this only. At this objection, that objection. We have directed that final hearing. The appeal is pending for 6 years. Start preparing. It may come up day after. We don't. What on? We have directed that the name of Mr. Ramesh Chandra be reflected. So it's not this thing.
In other respondents, Wakala, identification was not made.
Exhibit and signature shall be identified by advocate. It was identified. Now they have complained.
We have accepted.
Yes, ma'am. Yes.
Right down above that, before his name is reflected as counsel. Before that you write. Wakalat filed on behalf of by Mr. Ramesh Chandra, advocate, is accepted. Nothing, no excuse, no objection is pending. You will have to argue. Huh? No, you can seek an adjournment. We are not giving any date for what service of notice on the response is accepted. Yes, it has been admitted. Let the appeal be listed for admission in the next week. Is not working or what? WA number, you want it to be heard along with some WA. 1550 2019 list for 11 as prayed by learned counsel for the appellant, list for analogous hearing along with WA 15 bar 2019. What happened to Mr. Since issue to respondent number 2 has been served. Has been served on 21st April 23. So it has to be listed for admission. Let the appeal be listed for orders on admission. Has it been admitted? We are saying that admission, you are saying yes. 3rd February 2020. The appeal has already been admitted for hearing. Let the same be listed for final hearing. Hold on. Year 2 of 2023 for the reasons assigned in the application form are duly supported by an affidavit. Delay in filing the application for recall is condoned. So heard on IA 1 of 23 for the reasons assigned in the application form are duly supported by an affidavit. W number 250 bar 58 bar 258 bar 2020. This board can file in the result. Interlocutory applications are allowed.
Okay. Kumar.
Counsel for the appellant, respondent is granted. This time pertaining to assets and liabilities. We always focus on objection, right? Focus on arguments. Also. Sorry about, we will deal with it. That case also you are focusing on office. What remove? What have you done? So you want to withdraw that? All. Memo filed memo for retirement filed on behalf of Mr. Yep, Siddhappa is accepted, and office is directed to reflect the name of, it's already there. Reflect the name of Mr. P. Hegde and as counsel for respondent. Is granted to comply with office operations, failing which appeal shall stand this without prejudice. Please appeal. Last time was. Time was granted. All right, so we will deal with it in password round. Right? Current counsel for the applicant submits that the needful has been done. The aforesaid submission is placed on record. Office to proceed further.
Okay.
Current counsel, what the counsel for the applicant praise one is granted to each time to get the comply with office of. Valid counsel for respondent undertakes to supply a copy of affidavit filed on behalf of respondent to furnish the appellant during the course of the day. List when day after tomorrow. Yes, day. Yes, day after. Okay. We will decide it your application day after tomorrow. We don't need your clients present. Unless you agree for mediation, in that case, we will refer for mediation. So nothing, no application is pending, right? A final hearing. Fine. The day after tomorrow. The appeal has already been admitted for hearing. Let the same be listed for final. Will come up. you are not listed, file an application for early hearing. For publication. It's time to file memo. Take 6 months to. State counsel for the active praise fund is granted 4 weeks time to enable him to take steps for service of notice on respondent number 1 through publication. If 1 of 2 of 20 for the reasons assigned in the application, duly supported by an affidavit. I for service of notice on respondent number 1 through publication is extended accordingly. IA 2 of 23 is allowed. Then write this thing, place for this grant.
Number 21.
For the applicant undertakes to comply with office objection during the course of the. The appellant let office objections be complied with within 2 weeks. And for the appellant to model.
24.
It is sufficient, sir. Endorsement, Mr. So and so. The counsel for the appellant goes to endorsement indicates that the respondent has not taken the notice served him or her. Like below in view of the proceed. Endorsement service of notice of this. Admitted for hearing. This record. This is directed to secure the record of the claims of the.
25. Yeah.
Yeah, let's say more. 2 weeks time is granted to comply with office objection.
26. 26.
Not. That agency not known what does see the endorsement in the file. File an affidavit. You will act on your affidavit. See the endorsement. There is something written here. You are making a submission orally. We are inclined to accept, provided there has to be a material. Read counsel for the appellant submits that respondent has been served. Line below. However, office record indicates that what that the indicates that the respondent is yet to be served. So why don't you wait? It will come. We will list it after 1 week. Maybe that time, by that time it is updated. Why do you want to file? List after 10 days. Better. Awaiting service on respondent list after 10 days.
28.
The learned counsel for the applicant. The applicant has filed a memo seeking leave of the court for the appeal. The aforesaid memo is taken on record. Accordingly, the appeal. Time is granted to comply with all. What date? Tomorrow. Huh? Next Tuesday. What date? All right, fine. The counsel for respondent submits that the record has been received just on 6th of June 23. Please. That's what we are asking. What date? 6. Permitted. SPP submits that the statement of objection has been filed. He, however, pressed for short accommodation to enable the record pertaining to detention of the petitioner available for perusal of this court list on 6th of Oh, very good. Yeah, appreciate. Yes. You will file a memo of settlement. When? Like, password. You say settlement memo is ready. Why does it take you to so much? Huh? But that day also, two councils cannot address. You sit down, Mr. Let her. She wants to argue all the time. Yesterday, last time also, you did not take any lesson from the past. You should have sit down. It's an era of women empowerment. Sit down. Let her. She wants to argue despite the fact that matter has been settled. What can be done? Sit down. Sit down. Sit down. So how much time does it take for you to file? It's ready, you said. That's why we are asking. Where is it? Oh. 2:30. Fine. Any objection, madam? 30. Don't stand like this. Not a wrestling ring or something like that. We are not your opponents, right? We are trying to find out a solution to a legal problem, not like or not ring or something like this. That's why we feel intimidated and we find him very friendly. At least he smiles. 2:30.
Point of time to consider an application to stay of the.
It's final hearing. Yeah, let the appeal itself be listed for next week. 19,623.
34.
That instead of passing any order on IA P of 16 at this point of time, comma, let the appeal itself be listed for final hearing on so and so, right? That date. List on
96.
Number 34. Village. 34. The village. Martin. It was present and sought for engaging another counsel. He has not yet engaged. He also not present.
what right? Let a week's time, a week's further time is granted to the appellant to engage. List thereof, lying below, list thereof.
35. The academic.
Case of IA 1 of 20 and 2 of 20 has been served on the respondent, lying below. Despite service of notice, none has appeared on behalf of, neither anyone has appeared on behalf of respondent, nor any reply has been filed. Paragraph. The reasons assigned in the application duly supported by an affidavit, we find that sufficient cause for continuation of delay of 2 days in filing the appeal is made out. Accordingly, delay in filing the appeal is condoned. What stay, madam? Yes, sir. What made notes? What? The appeal. Is appeal.
Association rights to.
Which
Has been appeal against Camp of Station rights to.
the delay is condoned, IA is allowed. Appeal is admitted for hearing. And then say office is directed to reflect the name of respondent in the cause list.
Then further notice on finally.
You admitted, right? I also you pay, ask her to pay process fee, right? And we have said no, admitted for hearing issue notice.
Yes, sir.
Admitted for hearing issue notice. Then.
36. The temperature. The end.
You are senior counsel for this case. Who has filed this appeal? Get what degree? They have been granted.
Petition was dismissed.
Petition has been dismissed seeking dissolution of marriage. What state? Say. Right? What's your name? For respondent. Since the petition filed by the appellant seeking dissolution of marriage, has been dismissed, therefore in the absence of any executable decree, the question of grant of state does not arise. Accordingly, IA 2 of 21 is dismissed. Paragraph of 21 is dismissed as not pressed. Like below, appeal is admitted for hearing, directed to secure the record of the family court.
Petition 37. Narayan Bhatt.
What have you done? Have you deposited 10 crores? There is an order, Mr. Why do you say so? Para 6 of the order dated 18/4/23. Applicant would place in deposit 10 crores. Right. What I'm, yes, Mr. That's correct. Investigations are going on for revival. Said just now, second week. Negotiations of who said State Council for the appellant praised for and is states that the negotiations for revival of the company are likely to are taking place between the parties. In view of opposite submission, hearing is deferred this in second week of June 23, right? But please argue on the next date, third week of June 23. As said, we have already granted an adjournment to your senior, right? Is the matter. Huh? You'll have to tell us something about for seeking a passover also. Shifting of headquarters, right? What is it? So this court will decide where the headquarters should be, or the authority will decide. Like let your senior come. Passover. You be here. Will not adjourn this case today. Is appearing to oppose you. Huh? What is it? There is no post of general manager under the rule. Oh, work allocation means if there is no post of general manager, they cannot be permitted to function as such. What has been questioned? Secretaries and general managers. No, I mean, it is surprising. It is surprising that the person who should be aggrieved has accepted the order, and your ego, you have suffered this thing that how come our order can be this thing, we will take it to Supreme Court also, right? The persons whose this thing, posting and promotion have been quite, they have accepted. How can you, so Mr. Issue a fresh order of this thing, allocation, who prevents? Instead of fighting this litigation for now almost 2 years, you could have issued. What is, tell us what is wrong with the order? It's, office order, how are you agreeing? This assignment of work among secretaries and general managers. So we will say that it is quashed only to the extent so far as it pertains to assignment of work to general manager. Yes. That's why nobody is contesting. What's your name? HM Pradeep Kumar Lanet. Yeah. None for this. You are okay. Mr. So and so for 1 to District Government Advocate for respondents 1 to 4. Condonation delay of 8 days in filing the appeal. And below, for the reasons assigned in the application form is supported by an affidavit, we find that sufficient cause delay of days in filing. The delay in filing the appeal is condoned if result IA1 of 21 is allowed. Like below, heard on the question of admission. This intra-court appeal emanates from an order dated 5th of January 2021, passed by learned single judge, by which writ petition preferred by who was the petitioner? Respondent number 5 and 7. 5. Mr. Here you have written petitioner Mahesh PH. So by which writ petitions preferred by respondent number 5 and 7 have been allowed, and the order of appointments of 6 and orders of appointment of respondent number 6 on the post of general manager in Karnataka Industrial Area Development Board has been quashed. We have heard learned counsel for the appellant at length and have perused the report. Learned counsel for the appellant fairly submitted that he has no grievance in respect that counsel for the appellant submitted that the grievance of the and rest herein after referred to as the board in the beginning. The grievance of the board is confined only in respect of quashment of office order dated 23/8/2020. Insofar as it quashes the assignment of work even in respect of secretaries paragraph. We have considered the submission made by learned counsel for the appellant and the perused the record. Respondent number which he was promoted. Which respondent, Mr. Respondent number 6. Respondent number 6 in this appeal was promoted, was appointed as general manager by an order by a notification dated 27/11/2019. The thereafter an office order dated 13/8/2020 was issued in respect of assignment of work between the secretaries and general manager. Respondents number 5 and 7 challenge the aforesaid notification dated 27/11/2019 and office order dated 13/8/2020 in writ petitions before the learned single judge. Full stop. Learned single judge has inter alia held that under the which rules, Mr. Under inter alia held that under the regulations, right? Under the Karnataka Industrial Areas Development Board within bracket cadre and recruitment bracket close regulations 2019, comma. There is no post of general manager and therefore the point number 6 could not have been appointed on the post of general manager. The learned single judge therefore quashed the notification dated 27/11/2019 and office order dated 13/8/2020. Full stop. Paragraph. The learned single judge has rightly quashed the notification dated 27/11/2019, appointing respondent number 6 on the post of general manager, as there is no provision in the regulation for appointment on the post of general as under the regulation, there is no post of general manager, not appointment. No post of general manager, right? Full stop. However, it is pertinent to note that by office order dated 30/2020, assignment of work was made among secretaries and the general manager. Impugned the office order insofar as it the order passed by the learned single judge insofar as it sets aside the assignment of work to the secretaries is hereby set aside, line below. In the result, the secretary set aside, comma, as the same was not subject matter of the writ petition. Paragraph. The remaining part of the order passed by the learned single judge is maintained, line below. In the result, appeal is partly allowed. These improper appeals arise from order dated. Appeals. Court appeals arise from in WP number 0.2 and so on.
My lord, since this I'm appearing for appellant, my lords. CL number 40, my lords. My lords, I pray for a week time, my lords.
What is the reason, madam?
My lords,
What is the reason to seek adjournment?
my lords, senior is not keeping well. So the matter may be listed on next Monday, my lords. He'll do the hearing, my lords.
What will you do? You will do the adjournment and senior will do the hearing, like division of work, right?
Yes, my lords.
What's your all
I kindly
adjournment, all adjournments to your this thing and all arguments. This is right understanding, right? You will only appear to tell us that he is not well.
My lords, a
So,
week
no,
time.
we want to know from you, madam, what date you will begin, you will start arguing the cases? Which date? Tell us. We will note it down.
My
When will
lord,
you start? You have been enrolled to argue cases or seek adjournment?
to argue the matter, my lords.
When will you begin? Tell us.
My lords, I'll seek instruction. The next hearing date I'll do the. Yeah.
What is
Have you read the brief?
My lords,
Have you read the brief?
my lords, I just know the facts, my lords.
Learned counsel for the appellant prays for adjournment on the ground that the arguing counsel is unwell.
It was 41. I appear for respondents 1 to 3, my lords. My lords, in that matter, it pertains to BTM 6th stage scheme of BDA. My lords, I am told the Honorable Supreme Court has upheld the lapsing of the scheme in the other matters. I'll place it on record tomorrow. My lords may have it on Thursday, my lords. Kindly have it on Thursday. I'll place it on record. This court's order is approved by the Supreme Court.
E666. 59. Mr. Arun, it is covered by our order.
No, not your order. The Honorable Supreme Court on, yeah, I'll give the date, my lords, on
Covered by Mr. Arun, covered in your favor, not against you.
Oh, please, my lords, please.
Huh?
I'm sorry, my lords.
We don't think you have any objection.
No, my lords, I'm sorry, I'm sorry.
It's in your favor. He's telling us.
I'm sorry.
1st of February 23.
Please, my lords.
That may have been upheld by Supreme Court.
Yeah, it is upheld by the Supreme Court.
Yes, sir. This intra-court appeal mark the presence. Heard on IA number of 2020. Line below for the reasons assigned in the application, duly supported by an affidavit, sufficient cause for issue delay of 850 days in filing the appeal is made out. Accordingly, delay in filing the appeal is controlled. IA 2 of 22 is allowed. Heard on the question of admission. The dispute in this appeal pertains to lapse of scheme framed by the Bangalore Development Authority in respect of BTM 6th stage paragraph. Learned counsel for the parties jointly submit that the she's taking out now. Where is that Shakuntala madam?
Leaves. You can leave. Senate Council for the parties jointly submit that
the involved in this appeal has already been dealt with by this court-wide judgment dated 1st of February 2023, passed in WP number 17421-T2. And in WP number, in WP number 3667/2011 and WP number 59675/2014.
812 connected. They are connected. 81267.
These appeals have been allowed. If your appeal has to be dismissed, right? Or the line below, in view of proposal submission and for the reasons assigned by us in judgment dated 1/2023, passed in the so and so and so and so, right? Everyone. This appeal is dismissed.
I am grateful, my lords.
Please until the served and
Reducing basic pay. One increment.
Are 11. I mean, I have report right now. Can be done. There has to be some evidence. He had, according to your information, he had told the information to his distinct colleagues. Those colleagues were very much available. You should have examined them in the inquiry. It's not that you don't know to whom he had told. This with Justice Arvind Kumar. What is this? Yes.
Yes.
One format. So, read whatever para 10, 11. In the meanwhile, read.
Hence, considering this aspect, for the opportunity to have held the party against the diverse of the patient has been followed by the only on the and respondent. It's this aspect to show that
And he has stated that entire investigation pertains to other technical parts. Several technical parts are involved in out of them. One person has been he was having conversation with but all of them have to be coming together. Say, so it is very complicated. Program to go through. There is no way that they try to have contact with the staff, and if it is this divided and it cannot be done, there is no certificate in respect of sources of people, drivers and conductors, and they will really understand of the recorder and such power. It will then the recorder in his report at least the mode of conversation with the third party. It's in this regard, regarding the NCF, hence there is in the inquiry. Therefore, on the basis of that inquiry, punishment or the part of it is not saying liability.
He argued well. Yes. Because out of an order dated 4th March 2021, passed by a single judge, by which writ petition preferred by Karnataka State Road Transport Corporation. Herein after referred was the corporation, has been dismissed and the order dated 29/11/2019 passed in Justice Tribunal has been upheld. Paragraph. Facts giving rise to filing of this appeal at the relevant time was employed as a traffic controller, checking official, inline checking squad, a charge sheet. Articles of charges were served on the respondent on 30/9/2014. The charge leveled against the respondent was that he made messages from his mobile phone the conductors informing him about the checking programs. The respondent filed a reply to the charge sheet on 1/1/2015. The disciplinary authority was dissatisfied with the reply submitted by the respondent to the charge sheet and therefore proceeded to hold a departmental inquiry. Paragraph. The inquiry officer completed the inquiry and submitted the report on 10/7/2015. The disciplinary authority thereafter issued a show cause notice to the respondent to impose the penalty of reduction of his basic pay with cumulative effect. Thereafter, the penalty aforesaid penalty was imposed on the respondent. Full stop. The respondent paragraph. The respondent raised an industrial dispute before the industrial tribunal sued for adjudication. Full stop. The tribunal, by an award dated 29/11/2019, inter India held that the corporation did not adduce any evidence to prove the charge against the respondent. The office of the industrial tribunal found that the inquiry report the inquiry report was based on that the findings contained in the inquiry report were based on surmises and conjectures. Accordingly, the order imposing penalty was set aside and the reference was answered in favor of respondent. Paragraph. The corporation challenged the aforesaid award dated 29/11/2019 in a writ petition. The learned single judge, by an order dated 24th March 2021, has dismissed the writ petition. In the aforesaid factual background, this appeal arises for our consideration. We have heard learned counsel from the appellant at length. From perusal of the award passed by the industrial court, it is evident that no evidence was adduced by the corporation of misconduct. Full stop. Even the drivers or conductors whose statement was stated to have been recorded were neither examined before the tribunal nor before the inquiry officer. Full stop. The tribunal therefore has rightly concluded that there was no evidence to establish the charges leveled against the respondent. The aforesaid order has rightly been affirmed by learned single judge. Aforesaid award has rightly been affirmed. The award passed by the industrial tribunal has rightly been affirmed by learned single judge. In the writ petition, post of current findings of fact recorded by the industrial tribunal as well as the learned single judge do not call for any interference in this intra-court appeal. Line below. In the result, appeal fails and is hereby dismissed. What is it? What maintenance? How much? This is on IA for maintenance. So how much you are claiming? 55. Here you have said 15,000. In application, you say 15,000 and you tell us 25,000. Litigation expense. So what is your husband doing? we make an application for.
Did you make an application before the family court? Did you make an application before the family court seeking maintenance, interim maintenance? You haven't. What is your avocation?
The material to show the income of your husband, any payslip, anything, his designation.
What the children are doing? Children, where are they studying? Obviously, it has to be in school.
What is their age? Age. Of them 8 years. Twins.
Furnish some better particulars. How much fees they are paying to the school and all.
It comes for how much time? Additional affidavit you file? Which time? Within how much? Then it comes, then for Mark is present, then for responding. Even when the matter is called in second round, it comes for the applicant press firm is granted 10 days time to file an additional affidavit in support of claim of the applicant for matter. 38. 38. Yeah. Let it not be. They are hearing him on admission. You don't want us to hear him on admission. The last date is on. Shifting of headquarters. What legal representative? It's not your house. It's not your house where which is being shifted. What legal representative? Let him argue first. We will see where case for interference is made. Yes. What happened? This Okay, that's why you have to tell us. That's why we asked you what happened. You didn't tell us any facts straight away. You are what happened? Facts tell us what was challenged.
Actually, taking a lot. The board, the government will stay for now. Subject to the general of the or the precondition of me. Or price after previous proposal removed. He may change or now a proposal where the proposal did not contain any suggestion or proposal of change. I take my lords. What if actually, my lord. Scale number 90. Yeah.
Are you referring to page 172? Yes.
I've understood that in the proposal that section 4.2 does not provide that only on a proposal made by the state government headquarter can be changed.
Yes.
It doesn't say so.
Says so. And what instance the deputy
Because the resolution passed by the Gram Panchayat.
yes. So in this case, there is no resolution. Or therefore,
Bernard Singh just say there was a resolution by the Gram Panchayat.
as it will not be
So, Mr. For not telling us the facts in chronological sequence, reading section 4.2, reading 172. All this exercise has to be done by us. So please wait.
now.
Wait. If you don't want to tell, we will have to write an fine.
The determination was passed by the child.
Given in the beginning itself, definitely asking you. starts with first time, the resolution was passed, saying that and there are a lot of area. The various challenge some solution of people also. We already proposal in but therefore, Deputy Commissioner upwards. So, Mr. The only point is there any recommendation or proposal by the Gram Panchayat or a resolution? This thing that it should be this thing shifted to Chinehalli. $195. Go to 2015 is the resolution or what? Sir, he has read 4.2. Subject to orders passed by the government or subject to a resolution passed by a Gram Panchayat. Deputy Commissioner may change the headquarters. So in his synopsis, he has told us that there is no resolution by Gram Panchayat and no recommendation. Despite that, Deputy Commissioner has suo motu done without any recommendation or proposal. Sure. Yes. Did he file any objection to petitions? Your single judge writes no objection to it. We gave you an opportunity, you did not argue. We are trying to find out in our own what can be done. We gave you an opportunity to argue, you did not argue. What can be done? Trying to find out. Yes. No resolution. Based on such recommendations, the additional young was when there is no recommendation. What the government do?
Page number. 182, page 180. So referring to page number 187.
You are not telling the page number also. What lecture L means what?
Number 19. Chennai Nalli Gram Panchayat. Which column?
Because recommend like headquarter has been shifted when? When, since when is it functioning? Now, the deputy commissioner was page 139 or page Okay. What is the distance between these two places? Tell us. Satra and Chile, what is the distance? Can't be 500 kilometers. देखो मिला distance of other way. So that is that comparison is this is what having this specific of distance in because of one mistake of officer. Not noticing that there was no recommendation at all. He reviewed our. That's why therefore, he provided a section R. The order passed in division. Which page? National game. It's very short. Is due to delay. Which provision revision is quite much. What is the time limit? Pause. There was no objection filed for we had no objection filed. Now when now what is it? 77, please. 37, wait. Why we are asking you what is the limitation? Therefore, as per rules, time period of 1 month is there. Saying what we are asking you what is the limitation? Limitation. The rules it is prescribed of section 4. Say, not the power to condone the delay. Should confer power, no? Where under subsection 3, condone delay. Government in industry tribunal is also quasi judicial authority. No power to condone delay, that's what Supreme Court has said. Has to be conferred by statute. Correct. Yes, what else? The court. Last time we gave you the time to present the case. You are arguing it. You have given us this in- Please do not pretend that we should not put any question to you. The moment we will put a question, you will say, no, time should be granted to me to find out. Be ready. We ask. That's just your revision has been dismissed on the ground that it is filed beyond period of limitation. That's why we ask you that where is the problem. So you say that it's a court under land revenue code, therefore it has power to condone delay. I will bring up the facts. One has to ask to government. Not then. I don't know. Huh? Correct, correct.
Yeah, pregnancy. They say that it's already
It should be brought back. There are hotels there in both Sandra. It should be brought back. What is it? If it's functioning, it can be brought back. 2010 citation. What AIR or SCC? What? That application was filed something else. This is 98 Supreme. Not asking. What? No litigant can derive any benefit. There is no interim order. Party cannot be allowed to take any benefit of his own wrong by getting an interim order and blame the court. There is no interim order, there is no question of blaming does not arise. Yeah, but look at single judge. Or at a fact, I have heard it. At least now you will have satisfaction that there is no corona and this rate is also zero. No new patients have been found today. Huh? You don't know what is the distance between two villages. Here. Here. Order. Two, 3 kilometers, right? Tell us, simple we are asking by 2 kilometers. Huh? Long distance or other way? Kilometers you said, no? 3 kilometers you said. Fine, nothing turns upon the distance. Yes. It's a very big panchayat. How many villages are there? Villages of 30 villages. 50 people wants to 50. Without any recommendation. The reasoning is also not. Therefore, the impugned notification maybe mistake of fact, not recommended, but very simple. That's the reason. Yes. Was intimated to them, then on the date of notice, anything else? Now, it's on for identification. Whether it's a order. The resolution passed, was also supported by facts, mentioned in the whole indirect way, they had got you are appearing for which respondent list? You are appearing for which respondent? Intra-court appeal. eliminate. Okay. It's dated 14th of December 2020, passed by learning single day, by which writ petition preferred by the appellants had been dismissed, and the order dated 23/9/2019, passed in revision preferred under section 43. Yeah. Has been upheld. Paragraph. Next, giving rise to the filing of this appeal. These stated are that that by a resolution dated 14/3/2007, the Gram Panchayat resolved to shift the headquarters of resolved to shift its headquarters from village Chinahalli to Brahmasandra. Full stop. The aforesaid resolution was challenged. The aforesaid resolution was thereafter by notification dated 26/8/2008, the headquarters of Gram Panchayat were shifted to village Brahmasandra. Full stop. Right. Thereafter it appears that a proposal, thereafter it appears that on 9/1/2015, a notification was issued recommending redivision of panchayats and calling for objections for proposed redivision of Gram Panchayats by the state government. Full stop. In the aforesaid notification, there was no proposal of change of headquarters from village Brahmasandra to Chinnahalli. Full stop. However, the deputy commissioner by an order dated paragraph. However, the deputy commissioner by an order dated 2/2015, changed the proposal of change the headquarters of the Gram Panchayat from Sandra to Chinnahalli village. Right? It is not in the dispute between the two, the distance between two villages, namely Chinnahalli and Brahmasandra, is approximately 2 kilometers. The appellants challenge the validity of the aforesaid order passed by the deputy commissioner in a revision preferred under revision preferred under section 4 within bracket 3 of the Act. Full stop. The revisional authority by an order dated 15/10/2019 dismissed the revision preferred by the appellants on the ground that the same has not been filed within the prescribed time limit of 1 month. Full stop. Paragraph. The appellants challenge the opposite order passed by the revisional authority in a writ petition. Full stop. The learned single judge by an order dated learned single by an order dated 14th December 2020 has dismissed the writ petition and has upheld the order dated so and so passed by the revisional authority. In the aforesaid factual background, this appeal arises for our consideration. Paragraph. Learned counsel for the appellant submitted that headquarter of a Gram Panchayat can be challenged, can be changed only in the manner prescribed under section 4 within bracket 2 of the Act. It is further submitted that in the instant case, there was neither any proposal nor any recommendation made by any authority for shifting of headquarter of the Gram Panchayat. It is further submitted that the order dated. It is further submitted that the order dated that the notification dated 2/2/2015 issued by the Deputy Commissioner does not contain any reasons for shifting of the headquarters. It is also submitted that Learned Single Judge heard in holding that the change of headquarter is a policy decision. It is also urged that it is, however, fairly admitted that since 2017, the since 2017, the headquarter of the Panchayat is in village so and so, right? As no order of stay was granted in the writ petition. Stop. Village so and so. It is continuation. It is also contended that with passage of time, an illegal act cannot be termed as legal. In support of opposite submission, reliance has been placed on decision of Honorable Supreme Court in the Bharatiya. On the other hand, Learned Counsel for Learned Additional Government Advocate as well as Learned Counsel for Respondent number 11 has supported the order passed by the Learned Single Judge as well as the Revision Authority and have contended that at this point of time, no interference is called for in this writ petition paragraph. We have considered the submissions made on both sides and perused the record. The relevant extract of section 4 of the Act reads as under 4.2 and 4.3, right? Thus, like below. Thus, from perusal of the relevant extract of section 4.2 and 4.3 or 4.2 of the Act, it is evident that subject to general or special orders of the government and subject to provisions of the Act, the Deputy Commissioner may, at the request of Gram Panchayat concerned or otherwise, and after previous publication of the proposal by notification, may change the headquarters of any panchayat area. Section 4.3 of the Act enables a person who is aggrieved by the notification to file a revision before revision within a period of 30 days from the date of notification. Paragraph. In the instant case, the notification dated 4/2015, 2015, directing change of headquarter of Gram Panchayat reads as under. Relevant extract, page 119. Thus, from the perusal of the relevant extract, it is evident that the headquarter-wide notification dated 4/2015, headquarter of the Gram Panchayat, wide notification dated 4/2/2015 has been made on the basis of a recommendation of Gram Panchayat's redistribution committee. Redistribution committee. Full stop. The aforesaid notification. Stop. The revision would have been filed within a period of 30 days from the date of the notification. However, the same has been filed belatedly after a period of 4 months from the date of publication. No, no. Therefore, it is evident therefore, the contention on behalf of the appellants that the that the notification did not receive any recommendation does not deserve acceptance, right? Besides that, what have you said further?
Period of 40 days, the date of which were the same as we filed belatedly after the period of 4 months.
4 months, full stop. From perusal of section 4 within bracket 3 of the act, it is evident that it does not confer any power on the party to condone the delay. Full stop. The paragraph, the order dated 2/2005, the notification dated admittedly, the notification dated 4/2015 has been given effect to in the year 2017, and the headquarter of now the headquarter of the Gram Panchayat is situated in village so and so since 2017. The distance between two villages, namely Bon Brahma Sandra and Chinane Halli, is only 2 kilometers. Full stop. Therefore, at this the perusal of the order passed by the revisional authority, it is evident that new building was being constructed in the year 2015 for headquarters of Gram Panchayat. Full stop. The headquarters of Gram Panchayat are situated in Solso since 2017. Therefore, at this point of time, no interference is called for. For the aforementioned reasons, we do not find any merit in this appeal. The same points are before.
Implement.
The 23/9.
Not 1510.
23/9. Which item? Finally, it is only learned senior counsel so and so pays for a short accommodation this next week. Good. Yes, what is it?
Yes.
interact. I keep on.
Yes, whose petition this? Petition is dismissed. The wife's petition seeking maintenance is allowed. Maintenance order you are not questioning. Where is it? Before which court?
So, right, what is 13(1)(a)(b)?
Look into this. Relationship with another person. It says here for the letter, just that another person by the wife. But the letter is not established. The government is there. It's not established. It's going to When according to the husband, when the wife left the company of the husband, sir,
The date of marriage.
when the marriage took place, 4698. When the children are born, when? Two. Till how long? Till how long they were residing together? Yes. 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 2006. Hmm. Hmm. R22, exhibit R20. Hey, God.
What is the ground of cruelty pleaded by him? What have you done? What is where is the averment that which date you have, according to him, you have deserted her? Which date? Since when you have, there is no date, there is no averment in the petition that prior to presentation you have been living separately.
Including, as far as cruelty is concerned, there is no pleading. As far as desertion is concerned, he is saying that she has refused to join him. She preferred to work in a place where she was working. How much is the amount due? How much is the amount due in terms of That's all.
I have not read the findings of the family court at least.
Vera? So, which page? Which para? You are referring to internal page? What he has withdrawn? What he has withdrawn? Para number 6 and 7. All right.
His petition, we are not going to record a finding a illicit relationship. Your emphasis should be that desertion and ground of cruelty is not being proved. We are not going to record a finding in his appeal that he is having an affair with somebody. Please understand. Your submission should be that neither the ground of desertion nor cruelty has been proved. Question. Yes, it issue. Yes, yes, yes.
Make a section to it is
You
Yes.
can add it.
Yes.
Details here.
yes. Yes. Yes.
Yes, anything else? Acha.
Yes. Appeal is dismissed. First of all, appeal dismissed.
No objection to be complied with. Huh? Yes. Statement of assets and liabilities not filed. Why? No, 13 lakhs you have paid. He's remarried. Then you still want to press. Also only for this thing permanent alimony, right?
No, decree for divorce, you are not questioning. No.
What is the use, Mr.? Now he is already, you are telling that he is remarried. So if the decree is set aside, you will go and stay with him. It dispute is only with regard to this thing, permanent element, correct? So then there is no point there. That's what we are asking. There is no point in this thing. You only permanent alimony you press, that is understandable. No concern. We will decide it if you don't want. Why did you say that he is remarried? Argue, Mr. Then it's your case. Then argue. We have seen them. Date of birth. When was the petition filed? See, he is the appellant or you are the appellant? Huh? Huh? He will ask you if he is unable to answer. His appeal, right? He should feel that you are arguing his appeal. Yes.
Mother-in-law is still there. Mother-in-law still alive. What is the three persons' names are mentioned in the RTC? Who are other two persons? One is the father. Annappa is the father. Annappa's brother and sister. So what is the total extent? Sorry? Father will have 6 acres. There, he's having only 1/3 share. Father.
Much have you sought? David, see, Mr. There is an option, institute the proceeding under section 25, lead a proper evidence with regard to his income and get a decree. He will be making an assessment only, like the trial court has done, half-hearted attempt, only one line order. Say 2 lakhs, which is by all means is inadequate. We will leave this to your discretion. If you ask us, it is open for the court dealing with an appeal to grant permanent alimony, but it will be limited, right? Whatever the affidavit, he has not filed any affidavit, we will draw an adverse inference against it. But better that you adduce evidence with regard to his income, your expenses, and seek this thing. Right? That's all. I think we will hear you after the break. You think about it. What to do. But we don't know what you want. Next week. Learned counsel for the petitioner prays for adjournment. List next week. Wait, we are coming back. What? Wait, tell, if you are in a hurry, please tell. So we will adjourn provided, madam, we will adjourn the case provided other side has no objection. You will note it down. We are coming back. Not that we are not coming back. 2:30 we will be back. You are sitting since morning, you should have gone home. Why should you wait? I mean, we told you to tell him, right? You go home. Why should you wait here? We told you, tell him. If other side has no objection, we'll adjourn. But we don't want to begin the week with an adjournment. There's nothing great about adjournment. So, but you should have told, we granted you liberty at 10:30 itself. So what? He is praying for adjournment, not well. Huh? What do you say? Which case? No, not IA. This is final hearing, Mr. What you are not opposing the prayer for adjournment? Please argue, Mr. Don't seek an adjournment. 49. Correct counsel for the appellant pays for adjournment on the ground that he is not well. The appellant is not there. So have you informed them? You tell him. We will adjourn it later on. Not this. You go away, please tell him. Put down, Mr. We will adjourn it when it is called.
Court officer. Court officer. Court officer. Court officer.
Yes.
Matter that they're likely to report settlement. Yes.
One matter
Court
for
of-
reporting settlement.
Withdraw Matkan.
There is one matter for reporting settlement. One. Mention when. Yes, Mr. I think to argue, madam. I think to argue, it's being settled, right? So what have you thought about 25, section 25? Right? So please appreciate you have two children also, son and a daughter. Who will look after them? 15 lakhs in present time by any standards is a very reasonable amount. You know, what about this thing, Mr. Will you file 25 or you want us to determine? Huh? Yes. Hey, you don't have any income, you don't have any land, you are dependent on your father. Understood? What is the effect of not filing an affidavit despite two orders of this court? You know it better. And you did no. Will file means please. This thing by way of indulgence, 4 weeks time is granted. After he has argued, you can't say that I will file. Good file. We are trying to tell you, you should understand what are the consequences of not filing the affidavit. Yes. Right, you have understood, right? You don't have anything, you don't have any source of income, no land. That's why.
I have also.
You have to take care of 4 children and 2 wives. And even though she may not be your wife, but all this is, no, we may tell you all this is self-invited. You knew that this appeal can be decided against you also, despite that. That shows that you are a man of means. Otherwise, who would marry? If you can't maintain, if you can't maintain yourself and you don't have a source of income, then how will you maintain your second wife and the children? Sit. That's all. This appeal under section 28 within bracket 1. Marriage Act has been filed against judgment and decree dated 13th of August 2015, passed by the family court, by which by the trial court, by which petition filed by the respondent broke husband seeking dissolution of marriage on the grounds of cruelty and desertion has been allowed. So for the sake of brevity, the parties shall be referred to as husband and wife. Facts leading to filing of this appeal in nutshell are that marriage between the parties was performed on 22/4/2007. Full stop. It is not in dispute that out of the wedlock, namely Miss Asha, was born to the parties year 2008, and a son, namely Dheeraj. Master Dheeraj, was born in the year 2011. Husband filed a petition seeking dissolution of marriage inter alia on the grounds rated under section 13(1)(a) and 1 within bracket IEA and IB of the Hindu Marriage Act of the Act herein after Act. Act on or about 3rd of January 2014. It was inter alia stated that in the month of December 2011, the wife deserted the matrimonial home and thereafter flatly refused to join the matrimonial home. Full stop. It was pleaded that the wife has deserted the petitioner without any reasonable excuse and has failed to discharge the marital obligation. Full stop. It was also pleaded that it was ever that wife has ill-treated the husband, which amounts to cruelty, and has abused the husband by using Hindi language. He responded. Paragraph. The wife filed the objection statement in which a relationship between the parties as well as birth of 2 children from the wedlock was admitted. However, the allegation made by the husband with regard to mental cruelty was denied. It was pleaded that husband used to suspect her fidelity and used to torture her. The allegation, the averment made with regard to desertion was also denied. It was further pleaded that cause of action in fact has not accrued to the husband to file the petition. The family court. The husband in order to prove his case examined SPW1 and executed documents in the exhibit P1 to P8. The wife, in order to prove her case, examined herself as RW1 and 2 other witnesses, namely Swami and Guru Murthy BT as RW2 and RW3. The family court thereafter judgment dated 13th of August 2015. 2015. Inter alia held wife has treated the husband with cruelty and has refused to stay in the matrimonial home. Accordingly, it was held that the grounds for dissolution of marriage under section 13(1) of the Act are made out. Therefore, allowed the petition filed by the husband. In the aforesaid facts of background, this appeal arises for allowed before allowed, granted a decree for divorce on the ground of so and so, and full stop. In addition, the wife was held entitled to a permanent alimony of rupees 2 lakhs. Being aggrieved, wife has full stop. Being aggrieved, the wife has filed this appeal. Learned counsel for the appellant contended that learned counsel for the appellant has taken us through the pleadings as well as the evidence on record and has contended that no grounds for either desertion or cruelty are made out. It is further submitted that there are no specific instances of cruelty are pleaded in the petition, and similarly, the husband has failed in the ground with regard to desertion. On the other hand, learned counsel for respondent has supported the judgment and decree passed by the trial court. We have considered the rival submissions made both sides and have approved the report. This court by an order dated 24/2/2021, while admitting the appeal, had directed the husband to pay a sum of rupees 15 lakhs by way of permanent alimony. Thereafter, and had directed the parties and had directed the husband and wife to file the affidavit in terms of judgment of Honorable Supreme Court in Rajneesh versus Neha 2020 SCC on line 903. Correct? Yes. Whatever SCC. Thereafter, however, when did you file, Mr.? The appellant wife, the wife has filed an affidavit on 24/2/2021. However, despite opportunity being granted to the husband by orders dated 31/3/2023 and 19/4/2023, the husband did not choose to file an affidavit. Full stop. Error. Before adverting to the evidence on record, we may indicate the well-settled legal principles with regard to cruelty and desertion. In para 6, it is equally well-settled legal proposition that in a petition seeking divorce on the ground of cruelty, specific instances of cruelty have to be pleaded. Yes, like in class Thane. This also in the backdrop of the aforesaid well-settled legal principles, we may advert to the evidence on record. We may advert to the pleadings and the evidence on record. The perusal of the petition filed by the husband under section 13 of the Act, it is evident that it is evident that in para 6 of the petition, the husband has pleaded that in the month of December 2011, the wife left the house of the husband and went to her parents' house and is living with her parents. Full stop. In para 8 of the petition, it has been stated that the wife has deserted the husband without any reasonable cause and has repudiated the obligations of the marriage with an intention to bring the cohabitation permanently to an end. Full stop. Similar statement has been made in the evidence of the husband. Full stop. However, it has not been stated, however, as required. Section 13(1)(a) of the Act, it has not been pleaded that the parties have been living separately for a continuous period of 2 years immediately preceding the date of presentation of the petition. Full stop. In the absence of such a pleading and the proof, full stop. It is pertinent to mention here, really. It is pertinent to mention here that the family court has not conformed, conformed to the statutory requirement contained in section 13(1)(ib) of the Act, and without recording the finding that the aforesaid statutory requirement have been fulfilled by the pleadings and the evidence on record in a casual and cavalier manner, has held that the ground for desertion is made out. Full stop. Even otherwise, in the absence of any pleading and the evidence to prove the ground of desertion, such a conclusion could not have been arrived at by the family court. Paragraph. As has been noticed above, as has been noted supra, that to prove the plea of cruelty, party has to plead and prove specific instances of cruelty. In the instant case, paragraph 4 of the petition, the husband has merely pleaded that wife has ill-treated the husband with mental cruelty and has abused him in filthy language. Full stop. No evidence to prove the same. No independent evidence to prove the same has been adduced by the husband. Full stop. In addition, full stop, it is also noteworthy that the pleading with regard to cruelty is absolutely vague and general in nature. Therefore, however, the trial court once again, without adverting to the aforesaid well-settled legal principles in a casual and cavalier manner, has held that the ground of cruelty is made out. Full stop. Paragraph. The findings recorded by the trial court are contrary to the material available on record, and the findings have been recorded in a cavalier manner, without adverting to the statutory requirements contained in section 13(ia) what B and what of the Act. Full stop. So far, therefore, the impugned judgment and decree cannot be sustained in the eyes of law. Paragraph. So far as paragraph. So far as the claim of the wife with regard to maintenance is concerned, a bench of this court, after hearing the parties, had tentatively arrived at a figure of rupees 15 lakhs as permanent alimony. Full stop. Out of the amount of full stop, it is pertinent to full stop. In compliance of the directions issued by this court, the wife has filed an affidavit in which it has been stated that the respondent is an agriculturist and is the owner of following properties. 1, 2, 3, 4, like land bearing survey number this, like 1, 2, 3 acres. This fact is evident from the RTC extract annexed with the affidavit. It has further been stated that the husband has income of rupees 10 to 15 lakhs per year from the agricultural activities. However, the husband, despite being opportunity afforded to him, has not chosen to file an affidavit. Therefore, in the fact situation of the case, in the absence of any rebuttal, the averments made in the affidavit on behalf of the appellant, on behalf of the wife, have to be taken to be accepted. Full stop. Even otherwise, the wife is a housewife and has and 2 children who are school going and has to take care of school children who are school going. Full stop. Therefore, taking into account the status of the parties, and in the absence of any rebuttal on behalf of the husband, in the considered opinion of this court, a sum of rupees 15 lakhs is just an 15 lakh. It is just and proper. It is eminently just and proper to award a sum of rupees 15 lakhs by way of permanent alimony to the wife. For the aforementioned reasons, judgment and decree dated so and so, insofar as it grants the decree of divorce and grants the decree of dissolution of marriage under section 13 IA 1 and B of the Act is set aside. The wife is held entitled to a sum of rupees 15 lakhs. 15 lakhs is permanent alimony. Full stop. Out of the aforesaid amount, sum of rupees 2 lakhs has already been paid to the appellant. The remainder amount of rupees 13 lakhs shall be, the remaining amount of rupees 13 lakhs shall be paid by the husband within a period of 8 weeks from today. The judgment and decree passed by the trial court is modified to the extent mentioned above. In the line below, in the result, appeal is disposed of.
It's not divorce. Then it's 15 lakh alimony. In second marriage. Divorce. 15 lakhs alimony.
Wife is entitled or not? Section 25 doesn't say divorce wife. Wife. What? Tell us. Wife is entitled. Wife is entitled. It doesn't say divorce wife is entitled. Any court except is to be give you an opportunity to argue, right? You did not argue. After judgment has been dictated, you are arguing. The court exercise may at any time decree or any subsequent. Yes. Huh? Yeah, passed an order. Now, where will you come down? It's all over. Now you have to go up, no down. Read section 25. Read 25. It does not say divorce wife is in. Mister, we are not sitting here to convince you. This is what unfair. You people, no. You people, you people insist that judgment should be passed in your presence. We are doing it. Now, this should not result in like we are sitting here to convince you. What you obtain copy, challenge it before Supreme Court that only in case of a whatever. So yeah. We have seen. Huh? Hey, you have already told us. You have already told us this. You told us that December 2011 she went and this thing. Right? Can this court not pass an order after hearing you, Mr. Let this not be an occasion to re-argue once a judgment is dictated. That's why we never dictated in presence. But this is the result. You are arguing. Argue. We will hear. Argue whatever you want. Please argue. Please argue. Please argue. Yeah. Mr. That is the problem, Mr. Hegde, that but no, you have not read the petition of filed under section 13. There is no pleading. The what? Now, unfortunate part. I mean, this is what it takes. Like we should hear the argument. We should dictate in your presence, and after dictating, we should convince you. Right? Otherwise, you will argue. Huh? What the judgment may be wrong, but we are supposing if you would have succeeded, then you would not have said anything. Then fine. No, she is entitled to claim permanent alimony because you are remarried. Right now. It is last paragraph. It is also not in dispute that that husband during the pendency of the appeal has remarried. Therefore, the wife is entitled to live separately and is entitled to claim permanent alimony. Somewhere in the beginning, it will, right? Huh?
It's not applicable. It is in case party in whose favor the order is made as remarried. Order is not in your favor.
But Mr. Hegde, I was taken aback. You said that only a divorced wife. We are here. We are in this road. Just a minute. We are hearing in this jurisdiction for nearly 2 years. Nobody has ever argued that no, if the divorce is not granted, she is not entitled to permanent alimony. Read section 25. Fine. Thank you. Yes.
Both the marriages are valid now. Both marriages are valid now.
Why we are not saying anything?
Both marriages are valid.
Declaration that we can't do in a writ petition. But he can see it. Under 494 and gives the wife a cause of action to seek declaration that the subsequent marriage is not allowed. That because it has happened during my by this judgment and decree. We have held that first marriage has not been dissolved. So now
The
cause of action accrues to her to seek a declaration that this is it.
Second acceptance. Second acceptance. Gentlemen,
He should be blamed. This conduct see not could be. Yes. Use.
We the trial court as the minus be advanced.
Where are the terms and conditions of the compromise? Which paragraph so that we can
Start from paragraph 6.
parties along with counsel present. You are the petitioner, right? Petitioner along with her counsel present. Learned additional comment adequate for 1 and 2, and respondent number 3 along with his counsel present. This petition seeking a writ of habeas corpus has been filed for production of corpus of what? Who is the boy? Master? Vedant. Vedant, who is son of the parties. Paragraph. When the matter was called today, learned counsel for the parties as well as learned counsel invited the attention of this court to the joint affidavit filed on behalf of petitioner and respondent number 3 and submitted that dispute between the parties has been amicably resolved. The terms and conditions of the compromise have been mentioned in paragraph 6(2). Paragraph 6(2). 6(2). 6 to 31 of the joint affidavit, which shall be treated as part of this order. Paragraph in view of compromise arrived at between the parties. No, it is also stated before us that the custody of the minor son.
So finally, it is a joint.
Yeah. All right, we don't say anything like in view of the amicable settlement arrived at between the parties, the petition is disposed of.
Thank you.
Adjournment. Which case he was saying? He was saying that not well and sitting. Sitting said, I am unwell. What about 46? does CPC say? Council busy before another shall not be a ground for adjournment. You are asking us to act in contravention of law. Correct? Which provision? The CPC says. Tell us what is it. Tell us. What has learned single judge done? Huh? Huh. Become we are not able to provide it spending. What's wrong? You have acquired the land. No, you have acquired the land. Then are you not liable to pay compensation? Or is it your case that there is how this has been dealt with by learned single judge? Is it correct that they have deposited compensation? Whether it was notice was given to the petitioner. Did you inform him that the amount is in deposit? Please take it from civil court. This is not instructed. This is very difficult matter. The moment you are by your conduct, councils are suggesting to us that we should not dare to ask any question to them. Because the moment we ask any question, they will seek adjournment. Why are you standing here then if you don't have instructions? We will dismiss this appeal. What instructions? This is listed for hearing. Not tomorrow. Let him come today. What is there? How do you know that till 4:40? No. Madam, how do you know that he will be busy till 4:45? Who has told you? The bench has told you that no, the council cannot come till 4:45. Seek adjournment in all cases tomorrow. Then so this you will not argue. We will say that Shivram Karant arguing and you don't want to argue, therefore dismissed. So we'll say like this that you council is busy in arguing the matter pertaining to Shivram Karant layout and doesn't want to argue this case. And there is no urgency in this case. No urgency here. Landowner did not get compensation because he is dealing with BDA. He should die. His legal representative should be on record. This is what your object is, right? This is atrocious, man. You are an authority meant for the benefit of people. You can't behave like this. So, para 6, read para 6 of the order. It's very convenient to say that we issued notice under 12.2. Read the finding and show us where is the notice. That's why we ask. If you are able to show that 12-2 notice was issued to the landowner and he was informed that amount is in deposit, then you have a case. Otherwise, what? Para 6. To notice. How would landowner know that compensation has been deposited? Where's the document to show that 12-2 notice was given? Why?
Why that amount is deposited in civil court? Under what circumstances amount can be deposited in civil court?
Right, Madam Paswa. This case. They were seeking adjournment.
I appear for the appellant, my lord.
Yes, Madam. Counsel for respondent number 7 is unwell.
My lord, it may be listed after a week, my lord.
The presence learned counsel for respondent number 7 prays for adjournment on the ground that he is not well. List after 1 week. Should have told in his presence that it has become infructuous and he need not bother himself. Now we have told him that we will adjourn, and now you are saying that it has become infructuous. Please appreciate our predicament. He was 10:30, he made a submission. 1:30, he said, I want an adjournment. He said so in your presence. You said, fine, I have no objection. Now you are, once he is gone home, you are saying something. We don't know. Next time, please argue. She is also ready. But counsel we had assured. That's the problem. Because without adverting to you, say item number, we are 130, you say item number 60, then this problem comes. You should have told at that very point that he need not seek an adjournment. It has become infructuous. We would have asked the counsel for appellate. Now he has gone home. And we told him that we will adjourn.
Obliged, my lord.
Madam, find out whether it has become infructuous. And if it is so, you should say yourself, say on the next date of hearing. Don't wait for respondent to bring to our notice, right?
I'll obtain suitable instructions from the board, my lord. Obliged.
Petition filed by applicant.
Her husband.
Child was born on the May 2004. Now the child is 19 years old. When the petitioner working as impact basis. Wife was working as a school teacher. Then the dispute arose because of this not because we were not earning and she was in the open time environment. Because working in a local manner away from the place. Then the dispute arose for the reason that he never had money because of contractual needs to take the very not even 1,000 that too in 6 months. It was usually
But you still thought of getting married, right?
Yeah, that's what. But in the hope
That's what is called error of judgment. So your trouble started. Your trouble started when you decided to get married, right? Despite being penniless. Lighter vein, nothing to do with your case.
So you wanted her to quit the job. She refused.
Perverted, not perverted. Misconceived, that's a different. Not perverted. Judgment can't be perverted. Person can have a perverted approach. That's a different.
He was these undisputed facts available in the evidence and record show that the marriage was consummated. Got online job and decided they will fight side. Yes. There is no issue of so the question of wrong.
In a reverse order, right? You must come to the pleadings first, then evidence, then finding. So you are first reading, finding, then till you go.
Yes.
Thank
The maintenance case is not filed. You should be grateful. You can't raise a complaint. You should be grateful that maintenance case is not filed. What specific instances of cruelty you have pleaded and disproved? The cruelty is not the ground. Provision is mentioned, but what about the pleading and evidence?
Come to desertion, which paragraph you have pleaded desertion?
She's not. From that day onwards, she turned up. Given birth to a baby boy by name Chirag. Now his age about 9 years. After the birth of the child, she never shown the face. The respondent was avoiding showing this. Respondent has lost his feelings, felt due to the harassment. Submitted since 9 years. For 9 years, respondent is giving separately and even when she has not come forward to lead a marital life in spite of repeated requests by the that the respondent shows that she has got no love and affection, but no interest to lead marital. So, the establishment of affection. So, family
She has not admitted your contention. What she says is, you are not seen the face of the son. Your contention is, wife has not allowed. She has not admitted it. No admission. There is no admission as such. Admitted fact is father has not seen this face of the son, that is admitted. But who has not allowed, that is the question.
So, but what you are there, got some money. That was the way that. Day afterwards, whenever he used to go, or she used to come, he used to ask money. So she got
No, one logical inference is wife wanted the husband to stay with him, so she didn't pay money to him.
yeah.
That is one logical inference.
Get a council. Slow also. Because the reason that we other class. Now, high school only craft which are every student ನನ್ನ ಮೊದಲ ನೆನಪು ಮಾಡಿದ್ದೇನೆ ಎರಡು ಮನೆಯ ನನ್ನ ಮದುವೆ ನಾನು ಕೇಳಿದ್ರಿ Sakshi, solicitor,
From 2013 onwards.
He got only after 10 years of the marriage. Afterwards, he filed his petition because there is no meaning in continuing this. Also,
You have put a suggestion to the wife in the cross-examination. You have put a suggestion stating that wife is willing to stay with the husband since 2013. Ever since his job was made permanent, she wanted to stay with him. That is your suggestion. So where is the ground for desertion then?
now she's saying, what husband want to no relationship. I'm not seeing her face. She has not seen my face. There is no contact between the child and me. She has never allowed me to see the child also. Just for the sake of
You said that wife did not allow you to see your son, right? Did you file any petition seeking custody or visitation rights? And our evidence reveals that you have been visiting her for almost 10 years, up to 2010. No, that is her statement, but in the cross-examination, she has stated that he used to visit her. Which portion you are reading?
Statement that in the affidavit said that he has never seen the face of the sun. నాకు ఎడసలు
Read the next sentence.
not seen one point of the
Yes.
I am ನಾನು ಕೂಡ ವರ್ಷ ಚೆನ್ನಾಗಿದೆ ಸೊ ಮೂರರಿಂದ ಎಕ್ಸೆಲ್ exactly same facts. In marriage, section 41(1)(b), prohibits desertion. Any specifically.
Read para number 5. Read para number 5. Don't read headboard.
Yes. Marriage. Yes. Yeah.
See, husband was working in one place, wife was working in another place. She was in a government job. She was not transferred. Tell me, what is the attempt on the part of the husband to visit the wife during vacation? You are referring to the Supreme Court judgment. Where is the evidence by the husband to say that he made an attempt to visit the wife? You have not even filed a petition seeking custody of the child, not even visitation right. You have abandoned the son, only son for 9-10 years. And you wanted wife to continue in the government job because your salary was not good enough to sustain yourself. What is expected then? What is expected of a reasonable man in such an event? You have got concern for the child. You would have filed a petition. No, husband has also got a corresponding duty. It's not one way.
You don't. She also could not have left her job and joined you because you were, not earning. So that's why she was justified in living separately from you. What's wrong? There has to be intention of desertion. The fact that a son was born to you, that should What does it show?
The one thing, I was not earning. The second thing, my wife was earning. And even if I
No, despite that you wanted her to come to your place and leaving her job, right?
no,
Then what desertion?
yes.
Very simple. You are citing Supreme Court judgment to say that wife did not visit you during summer vacation. Same applies to you also. You did not visit her.
She was she has she comes here, she has to take care of. That is a reason actually. So, even after 1 year, right, she agrees to come. Only for this. Even if I come, I'll be happy. So I don't. So for 10 years. No, law there's no law application, there's no contact, 19 long years. There is no meaning in continuing to this. And it's not. Para 4, I agree. But people select and Mr. AK learn senior yeah, learn council. There is a different pathway to the right and also come. You have several applications. I'm possible for right to same inside. Not be substantiated.
That is not the case here. That is not the case here.
So please understand that's the power under Article 142. We don't have that power. Supreme Court itself has said that High Court cannot dissolve marriage, divorce, the grounds under Section 30. Why are you reading this? This is of no assistance. In facts of that case, Supreme Court has exercised power under Article 142. That they can do. Fine. We don't don't argue that we will exercise power under Article 142.
I'm not asking for that. I'm asking that the ratio
take out of ground under Section 30.
Yes, sir. There is no 19 years. There is a 19 years reduction. There is not even no chance of being together. I think picture shows here, they are not even present here and arguing the matter. That picture shows that they are related to the not only yes, my
Like in all the cases where counsel is not appearing, we should draw that inference according to you. That they are not interested, appeal allowed. Wish we could do it. We only pray that you don't come across an application seeking recall on the ground that order has been passed in violation of principles of natural justice. The counsel for respondent was unwell, suffering from fever.
These grounds are I'm seeking for knowing my appeal. The one thing is that since 19 years, there is no.
What happens to your son? What happens to your son?
And she's capable of taking care of this thing. And even I actually gave instruction to conduct mediation with my office. I'm ready to pay something to my son. I categorically stated that. Even earlier also, at least 100 times I called him. And the exception in my friend is something to secure my son.
We don't know, and this all not relevant.
And he has not filed any maintenance.
That's why my lord pointed out, right? You should be happy about it and not complain. Not complain that she has not filed any application. Good.
Yes.
Must be 53, right? Nearing the age of superannuation. Live in peace now. Not nothing for both. We have not expressed it. We have not expressed any opinion, right? We have just asked, please argue. It is neither here nor there. He will remain ghost or whatever.
And they are really separately. Respondent has neglected himself. Respondent never took the responsibility.
He asked the wife to come and stay with the mother. He refused. And she left.
Yes.
Essential ingredients of investment. Four ingredients. We are separated since animal specificity in the
House separation is good. You were posted in different place. Your wife was posted in different place, even before marriage, knowing full well you married her. And then you are saying that she is not staying with me. How? What she will do?
no contact. He must especially before he get got a government. Sure, at least take responsibility. And absence of consent. Without consent, without any reasonable cause. It's a big
When you are married, at which place you are residing? You are married. Padur. She was working in. How far the distance? Yes.
It's not as shepherd by any effort.
How your effort is established? You have not led any evidence. Who is the witness examined? Who is the witness examined? None.
So now, your submission, as we have understood, is that supposing wife and husband are posted at different places, the burden is on the wife to join the matrimonial home, failing which desertion will be proved. Right? This is the argument. She was posted at different place. She did not come to me. Therefore, desertion is proved.
She never. She came to. She has not filed any maintenance case when something is not filed. There's no restriction.
No, so maintenance case not filed means desertion proved. You are relying on this. Maintenance not filed means. What have you done for your son? Nothing. He is 19 years of age. You are only interested in divorce. What have you done? Your wife has single-handedly got him up. And just like that, you are arguing desertion and all. What have you done? Nothing.
I will answer this. Answer something.
It's established. It's not established.
Where have you stated your evidence? Read it. Very good that it's a walkover sort of situation for you. You should be thankful that they are not appearing. Task is easier now because there is nobody to oppose.
No. If they were there, I would have been very easy.
Yeah? Right? Now nobody there to oppose. That has to be decided by the court, not by you. I am taking divorce. You are saying I am taking divorce. That you can't decide. Court will decide.
Under which provision we can seek divorce against his son?
Yes.
It's really surprising your conduct. Don't you feel that not, I mean, taking any steps to even meet your son? So surprising. And now you are at the time of hearing, you are saying all sorts of things. What? You understand, right? You understand you are a father. You understand, is it not an abnormal conduct? What is there to answer? Nothing. In any case, it is not for, it doesn't form part of the judgment. Yes. Anything else?
Marriage.
That is under, again, we are telling you under 142 list. Why don't you understand? Irretrievable breakdown of marriage. 140. This court cannot grant decree on ground of irretrievable.
My entire case has not been very good from perspective. Whatever reference given, whatever process not been very good.
Yes, that is correct. That you can argue. What else?
Maybe some people can pick up fires. Otherwise, we will remain as a ghost. Will not be here. Neither husband and wife will be like this. Yeah. Time period. Even
Shows that this court has power. There is a decision of the Supreme Court itself where Supreme Court has said that power under Article 142 cannot be exercised by High Court. What are you talking about this? No, nothing. Don't seek an adjournment. It's not that like no. So tell that power under Article 142 can be exercised by High Court. Irretrievable breakdown of
Yes. Any other grounds? That's all. The appeal is under section 28(1) of by the husband or the petitioner in MC number 28 of 2013 on the file of senior civil judge. Petition filed by the husband in section 13(1)(1)(a) and 1(b) of Hindu Marriage Act, seeking dissolution of marriage of liberty and desertion is dismissed by the trial court. Reviewed by the aforementioned judge, appealed by the husband. Three facts necessary for the adjudication of the case can be raised as a parties to the proceeding were married on 11/5/2003. The petitioner was working as a temporary teacher, whereas the respondent wife was working as the permanent teacher in a government school. Admittedly, the both of them were working in a different places. And petitioner was working in Kadur and respondent husband was working in Kadur and wife was working in Aigurala. Aigur.
Yeah, be simple. There has to be an end to everything. You cannot go on arguing.
Is the contention of the husband that son was born in which year?
2000.
Which year? 2004? Son, yes, 2004. Son was May 2004. he further states that he was getting a meager salary, wife was getting a higher salary, and she never took up the responsibility towards the husband, and she left the company of husband in the year 2004, and thereafter she never returned. It's also his contention that his mother was not keeping well, and he requested his wife to come to his house at Kadur. However, the wife refused to join the house of the husband. Further states that after having left the company of the husband, the wife never returned to his fold, and he has sought a dissolution of marriage on the ground of cruelty and desertion on the basis of facts related above. The wife has contested the matter, and she has denied the allegations leveled against the wife. It's also her contention that the wife thought it appropriate to continue with her job, as the husband was not having a permanent job. She was having a permanent government job with a higher salary. Wife thought it appropriate. Wife felt it necessary that to look after the son and the family, she has to continue in the job. And it is also a contention that she is ready and willing to stay with the husband. And there is no cause of action against the wife to seek dissolution of marriage on the ground of cruelty and desertion, and has prayed for dismissal of the petition. Before the trial court, the husband is examined as PW1 and was produced. Not produced any documents. Exhibit P1. He has produced one document which is marked Exhibit P1. Stop. Wife is examined as RW1, and no document is produced on behalf of the wife. The trial court has concluded that the plea of cruelty and desertion is not established by the husband, and accordingly has dismissed the petition. Reviewed by the aforementioned judgment and decree, the husband is in. The learned counsel appearing for the husband would contend that the husband has established his contention relating to plea and desertion, and the same is also evident from the admission given by the wife in her cross-examination. The trial court did not appreciate the oral evidence in proper perspective. Erroneously dismissed the petition. Also, his contention that since 19 years, husband and wife are staying together and they are residing separately, and wife has not allowed the husband even to visit his son on the date of his birth. The trial court has failed to appreciate all these factors, and erroneously concluded that the husband has failed to establish the plea of cruelty and desertion. In support of his contention, the learned counsel for the client would also place reliance on the judgment of the apex court as well as the judgment of the Rajasthan High Court and Patna High Court. This court has considered This court has considered the contentions raised at the bar, and also perused the record and the judgment cited at the bar. So, an admitted fact that husband and wife were both employed when the marriage took place. Admittedly, the wife was working in a different place and the husband was working in a different place. And the wife was having a permanent job. The husband was having a permanent job, was not permanent. The wife was getting higher salary than the husband. The overall contention raised by the contention of the husband is considered from the perspective of the husband. It is evident that husband is asserting the ground of desertion on the premise that the wife is not staying with him. As already noticed, the wife was working as a teacher in a government school away from the place where the husband was residing. And that being the position, the wife was staying that particular place where she was working cannot be construed an act of desertion on the part of the husband. However, this pleading relating to desertion is also not as per the requirement under section 13(1)(b) of Hindu Marriage Act. As far as allegation relating to cruelty is concerned, it is to be noticed that except stating that the wife refused to join the house of the husband when the author of the husband was allegedly will, nothing is pleaded or nothing is brought before the court in the form of evidence giving details about the specific illustrations of cruelty. The trial court has analyzed the evidence on record. Yes. As far as evidence is concerned, except the petitioner reiterating the averments made in the petition, he has not led any other evidence to substantiate his contention. Whereas in the cross-examination, it is suggested to the wife that wife has expressed her intention to stay with the husband after husband's job became permanent. Full stop. This suggestion itself would indicate the fact that the wife is still willing to join the company of the husband, and it is the husband who is not ready to stay with the wife. Full stop. It is also forthcoming from the record that the husband has not made any attempt to seek custody of his child or seek visitation rights when he has alleged that the wife has not allowed him to see his son. On the other hand, the wife in the cross-examination has stated that husband used to visit him and used to visit the son whenever there was vacation, full stop, and that visitation continued up to 2010. This being the position, and also considering the fact that the husband has not filed any petition seeking custody or a visitation right, this court has to accept the contention of the wife that the husband used to visit the son once in a while, where she was working in Aigur. Full stop. From the evidence placed on record, this court is the view that the husband has failed to produce any acceptable evidence to accept the contention relating to cruelty and desertion. Paragraph relating to pleading and proof of cruelty and desertion is well settled in terms of the judgment of the Honorable Apex Court in the case of so and so. As far as the judgment relied upon by the learned counsel of the appellant is concerned, the case of Gita Jagdish Mangtani versus Jagdish Mangtani, the Apex Court has taken a view that the marriage between the parties is irretrievably broken down, and there is no point in dismissing the petition and asking the parties to lead the marital life. And in exercise of power under Article 142 of Constitution of India, the Apex Court has granted a decree for dissolution of marriage. And it is also required to be noticed that in the said proceeding, the wife has taken a contention that the husband has married again. So, same is not the situation in this case. For the aforementioned reason, this court is a view that the facts of the case referred supra is not applicable to the case on. And even in the case of Rishikesh Sharma versus Sarosh Sharma, 2007, 2 SCC, 263. The Apex Court has exercised the power under Article 142 of Constitution of India, the premise that the marriage between the parties has irretrievably broken down, and granted a decree of dissolution of marriage. This court is not exercising the power under Article 142. Apex Court cannot exercise the power under Article 142 And same has been clarified by the apex court in various judgments. What is this Rajasthan High Court judgment? Which paragraph? There are only 17 paragraphs. Sorry, Patna High Court judgment. Yes. As far as the judgment relied upon by the learned counsel for the husband, in the case of Sandeep Kumar versus Srimati Sonali Kumar, AI 2008, Rajasthan 75. It is to be noticed in the said case, the court has taken a view that the husband has proved his case, that the wife has deserted the company of the husband with an intention to put a permanent end to the marital relationship. We have already analyzed the evidence placed before this court. From the evidence placed before the court, it's apparent that wife was staying in a place away from the husband's house, as she was employed as a government teacher in a primary school. It was away from the house of the appellant. That being the position, the act of wife staying away in a place away from the house of the appellant cannot be termed as an act of desertion. Hence, the ratio laid down in the aforementioned case is not applicable to the facts of the case on. Then Patna High Court, which paragraph? Paragraph 14. As far as of the Patna High Court, the case of Yo Kumar Shah versus Dalip Kumari Shah, AI 2009, Patna 4, referred to by the learned counsel for the husband is concerned. In the judgment, it is apparent that the husband in that particular case has established the fact that he has made an attempt to secure the, he has made an attempt to bring in conciliation between himself and his wife. And despite his efforts, the wife has refused to join the company of the husband. Whereas in this case, there is nothing in the pleading to show that husband has made an attempt to bring the wife back to his marital. But evidence is not laid on the part by the husband to show that he had made an attempt to ensure that the wife is back to his matrimonial home. The government is made in the plain stating that wife has abused the mother of the husband. Mother is not examined for the reasons specific to the husband. For the aforementioned reasons, this court is the view that the ratio laid down in the judgments cited by the learned counsel for the husband are not applicable to the facts of the case, facts obtained in this case. We have also gone through the judgment reasoning assigned by the trial court dismissing the petition seeking dissolution of marriage. The trial court has given a finding that the husband has not established the plea of cruelty as well as desertion. And trial court has also come to the conclusion that wife was staying away from the husband on account of her avocation as a government teacher in Igor, and the act of wife staying away the husband cannot be construed as an act of desertion. Under these circumstances, we are of the opinion that there are no grounds to grant the decree for resolution of marriage by setting aside the well-reasoned judgment and decree passed by the trial court. Accordingly, the appeal is dismissed.
Said yes.
Appear for appellant, my lord.
Yes.
Not being aggrieved by the granting of divorce by the trial court in favor of the respondent wife, my lord, I am before this honorable court, my lord. My lord, kindly turn to the issue framed by the trial court, my lord, at page 22 of the judgment, ink page 22. Paragraph 17. May I read, my lord? The point. May I read, my lord?
Yes, yes.
The point that arises from my consideration is whether the petitioner proves that her husband has been cruel to her and there is danger for her life, and it would be unsafe for her if she cohabits with the respondent, and hence she is entitled for divorce under section 13(1)(1)(a) of the Hindu Marriage Act. My lord, the main contention of the respondent wife is that, my lord, I tried to kill her, my mother tried to kill her, my brothers tried to kill her, and my lord, I have an illicit relationship with another woman in my office. My lord, not even a single iota of evidence is produced, and in the cross-examination itself, she differs from her own grounds. My lord, the trial court comes to a conclusion on flimsy ground of technicalities that only because a dowry harassment complaint is filed, all the allegations are proved. This is the observation by the trial court, my lord. My lord, kindly turn to page 25, my lord, paragraph 21 of the judgment. Ink page 24, paragraph 21. Married, my lord. She has further denied that her father is dead against for her to live with the respondent, and further denied that the respondent never took any financial assistance for her establishing a business and for getting house on rent. She has further denied the suggestion that respondent is getting a good income and is able to take care of them financially if she herself and her daughter returns to the matrimonial home. She has further stated that the respondent got a signature forcefully to sell the agriculture land in the village at Alur. She can produce the loan documents from the bank wherein her father obtained loan for 2.5 lakhs in order to pay her to the husband. That she has not given any complaint to the police against her husband's partner Maqsood and against her mother-in-law. My lord, next 4 lines is important, my lord. That she has not made any complaint against her mother-in-law when she attempted to kill her by keeping the knob of the cylinder open in the kitchen. And further, she was not admitted to the hospital when she admitted to commit suicide. She has admitted having given complaint against her husband after 8 years. her husband is having affair with one Soumya who was working with him in his organization. Her mother never suspected her character as she has not done anything wrong. My lord, I just preamble to this, my lord. The marriage between the appellant and the respondent, it is a love marriage, my lord. They eloped and against the parents of their marriage, they got married. Everything was fine, my lord, until 2011, when I suffered a peculiar disease called lumbricosacral. It is a spinal cord disease where I became partially disabled. After that, my lord, I was still working. I was earning 6,500. My lord, her main contention was to grant divorce because I became partially disabled. My lord, she files, after 8 years, she filed dowry harassment first. Then she files domestic violence. Then she files maintenance. My lord, the domestic violence in 2015 and the interim maintenance application of 2015 got dismissed. The observation in the domestic violence case is that the violence has been occurred upon the husband, not on the wife. This is the observation by the trial court. Both got dismissed. Not even a single penny was ordered as maintenance because the conduct of the respondent was deliberate in getting separated. She was coercing him to get divorced. Only she was filing cases after I became disabled. My lord, the trial court, see the observation of the trial court at page number, ink page 29, my lord. Paragraph. These two paragraphs will, my lord, they will clearly exhibit the erroneous observation by the trial court, my lord. Page 28, it starts, my lord. 20. I'll read from 27, 29, my lord. First line. 27, ink page 29, my lord. Sorry, 29. Continuation of paragraph 26. I'll read from the first line, my lord. No reply has been from there, my lord. May I proceed, my lord? No reply has been sent to the said exhibit R2. R3 is the medical report in the respect of the respondent suffering from lower limb arterial problem. He has also produced exhibit R4, the disability certificate and identity card for differentially abled person issued by the Directorate for the Empowerment of Differentially Abled and Senior Citizens, Bangalore, wherein the photograph attached to it becomes clear that he is not normal man and has some problems in the limbs. From the above evidence from the criminal proceedings between the parties, it becomes clear that petitioner and respondent, though married and lived together for 7 years, could not live afterwards happily and lovingly. Their matrimonial life has become disrupted. Though there is no evidence put forth to come to the conclusion that the respondent is having an illicit relationship with one Soumya, in spite of Exhibit P7, the charge sheet, Exhibit P5, the FIR, and Exhibit P4, the private complaint filed against the respondent, and the appended document of the charge sheet clearly goes to show that the respondent has physically assaulted the petitioner and was demanding dowry and abusing her. Even no person of ordinary nature would abuse her mother-in-law to the extent of trying to kill her by opening the gas knob unless the same has been attempted by her. Even the respondent, her family members were also brought to the police station and they have been inquired. When all these are taken into consideration and the allegations made in the petition, in the evidence regarding the physical harassment, mental cruelty, and illicit relationship of the respondent with one Soumya is highly probabilizes the case of the petitioner. There is every threat to her life in case she lives with the respondent, as she has already suffered the trauma of being killed by her mother-in-law by opening the knob of the gas cylinder in the kitchen, and she has attempted to commit suicide. I pause for a moment, my lord. My lord, the previous observation was that I had no illicit relationship with Soumya, no documents were produced. In fact, my lord, my mother-in-law is a village lady. There is no gas cylinder in the house at all. In the FIR, my lord, which is marked Exhibit P5, there is no allegation. In the charge sheet, my name is not citing. My brother's name, my mother name is not citing. This is a total misconstruction by the trial court, where it comes to the conclusion that mother and brothers are involved in trying to kill her. There is no name in the FIR, my lord. Only husband's name is there for dowry harassment. That's all. After, my lord, till today, even charge is not framed. Meanwhile, the other two cases which were filed, that is for maintenance and domestic violence, has been dismissed. There is no ground in the same, all the petitions, same grounds were urged. Nothing has been proved. The trial court comes to the absolutely wrong conclusion that I tried to kill her. I have an illicit relationship where it has negated its own its own grounds. My lord, if my wife had become disabled, I would have never separated in the matrimonial life, my lord. My only concern is the kid, which is now 17 years. I was paying the school fees. I was taking care of my wife, everything. Only on the ground of being disabled, my lord. If the divorce is granted on this flimsy ground of technicalities, my lord, there will be no sanctity of the marriage at all. My humble submission is, my lord, if you 2 pages of the cross-examination, my lord, 2 pages of the cross-examination will prove absolutely a frivolous case was filed by the wife. My lord, kindly turn to the cross-examination, my lord.
We'll continue tomorrow, Mr.
Please, man, please.
Tomorrow.
Much obliged. Please.
Very good. Let me say.
My lord, I have a submission. I am for respondent number 1 in serial number 46, my lord. I have received the NOC. My lord.
1 minute. We are. Yes. Mediation Center at Mysore. Right. 60. Learned Council mark their presence. Learned Council for the parties jointly submit that there is a possibility of amicable settlement of dispute between the parties. It is also submitted that parties are ready and willing to appear before mediation center on such day as may be fixed by this court. Paragraph. In view of opposite submission, parties are directed to appear with the Mysore Mediation Center on what date? June 23 at 3:30 p.m. Right? Huh? Who appears against you? Form. Learned Counsel for the appellant submits that he is not available on account of personal difficulty list in the next week.
My lord, I am for the respondent number 1 in serial number 46, my lord. Today only I have received the NOC Bakala. I kindly pray for 2 weeks time in this case.
And we are still attending other matters. We'll come back to you.
Okay. My apologies.
Why, madam?
My apologies.
And what is the urgency of granting adjournment? No, nothing. It will be repeated tomorrow. Yes.
In this matter, for 3 weeks time so that I
Yes.
I'm ready. I'm ready in the matter, but I have to take instructions if I can go on with the matter.
When do you want? After?
19th of June is a Monday.
Learned additional government advocate prays for adjournment. Mark the presence, right? Learned additional government advocate prays for adjournment. Ground that the adjournment to enable her to prepare the case and mark the case. Listing week commencing 19 June 23. I can give it. Keep it, Mr. Tag it and keep it properly. Yes, madam. Yes. It disappeared.
My lord,
My lord, I am for the respondent number 1 in serial number 46, my lord. So just today I have received the NOC wakalat from the respondent number 1. So I pray for 2 weeks time to file wakalat.
Where were you? It is passed over, madam. Passed over case.
It is passed over.
Where were you?
I was in city civil court, my lord. My apologies.
You are telling the High Court that you were in city civil court. Huh?
My apologies, my lord. I couldn't.
Tomorrow you will see. No, tomorrow. If
I couldn't make my submission in the morning.
Tomorrow you will say that I have to cross-examine a witness. Therefore, the case should be adjourned. Right? I have to cross-examine before city civil court. Please understand the order of precedence, madam. What is this? You are appearing in 46. He's praying for adjournment. We grant you a week's time. 2016 matter. It's not, it doesn't come as a matter of right, madam. 7 years it's pending. And what does section 21 says of Family Courts Act? How much time it should be decided? Huh? Appeal should be decided in 6 months. 7 years have passed and you don't have any this thing, absolutely this thing, just you are seeking like 3 weeks, 4 weeks. Why should we permit? Tell us when the law itself requires. It's the reverse situation where the court is ready to hear and you people keep on seeking adjournment all the time. State Council for Respondent prays for adjournment list after 1 week. It is made clear that no further adjournment shall be granted.
Much obliged, my lord.
You want other cases to be adjourned? So,
serial number 50.
Tomorrow.
Sorry, Marat, serial number 57. They want to request some referring the matter to a mediation. Marat. They want there is a likelihood of settlement. 57. Marat.
Where Bangalore Mediation Center. Same order.
Bangalore mediation.
When will you appear?
Marat, as you feel, Marat. Any date may after 2 weeks, Marat, they can. Because
12 June 2023 at 3:30 p.m.
Lord, serial number 62, Lord. 62, the final matter.
It will be called tomorrow. You want to argue, right?
My lord, no. My senior's daughter's marriage is coming up.
No, then wait for tomorrow. Yes, you will not come to court tomorrow.
I will.
Yes, my lord, serial number 54. Serial number 54, my lord. My name may kindly be correctly be shown, my lord.
You are aware, right? It will maybe tomorrow it's taken up and your name will never be shown in the list because case it is decided. Now focus on decision instead of your name, right? Tomorrow.
Please.
ಒಂದು ಆಯ್ತಲ್ಲ ಕಟ್ಟೆನಾ